Good evening, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. Do we have a lot to talk about today? You bet we do. What's the first thing I'd like to talk about? Well, little thing happened in Idaho today. Unbelievable is the only way to describe it. But we will explain what took place in regards to the matter of Lori Vallow and why she now will no longer be eligible for the death penalty if the prosecution can prove their case beyond a reasonable doubt that she is responsible for the deaths of J.J. Tylee as well as Tammy Daybell. Like to talk about that. Then also like to talk a little bit about little Alec Murdaugh audio recording from the jail to his attorney being released by mistake. I got a real problem with the jail recording attorney-client phone calls. I get it. Alec Murdaugh's been convicted. I get it. But, the whole point of being able to talk to your attorney is that you should have no restrictions. No one's listening to you. That it's going to be confidential so that you can be completely truthful and candid with your attorneys. So I got a real problem with that. So as we get going here this evening, we are obviously live here on YouTube, Facebook, Twitch, Rumble, and is there anything else? And CrimeTalk TV on Roku. That's right. We're everywhere. You can find CrimeTalk everywhere. So there's no reason why you shouldn't watch. And as we wait for kind of the numbers to build here, we'll talk about the Lori Vallow matter in a second. But for those of you who maybe are just joining us for the first time or say, why should I listen to this Scott guy? Well, Scott's been doing this for a long time. Scott's been doing criminal defense for 28 years. And what Judge Boyce did today is something that I have only seen, not particularly a death penalty case. I mean, normally the judge doesn't get there. But basically, kind of what he's saying, and we'll get to it, is this case is so screwed up, it's coming back on appeal anyway. So let's just take the death penalty off the case. And can we get done with this thing enough already? So we have a lot to talk about there. And what are the options? What are the options? What can the prosecution do? What about the victims? What about the grandparents for J.J. Tylee, right? The Woodcocks. Let's just say I've had on some good information. Not happy. We'll just leave it at that. Not happy with the judge at all. And since this is kind of a big area to talk about this evening, I think we're going to open up the phone lines, and not just for our Patreon folks there at home, but let's also do it for tonight as well. So you can call in. We'll have a conversation. 725-228-TALK, 725-228-8255. And the computer will prompt you to tell us your name, what you want to talk about, and with only one rule. You have to be talking on your phone. You can't use a computer because there's the delay. All right. So let's get to the news of the evening. First, Lori Vallow, obviously charged as it relates to the death and disappearance of her two children, JJ and Tylee, as well as a conspiracy as it relates to her now fifth husband, the death of Tammy Daybell. Mysteriously died just a week before the nuptials between Lori and Chad, where they ran off to Hawaii. I mean, let's face it, the islands there are romantic. Who couldn't be persuaded to go there, right? But when your children are missing and no one can find them and you don't really tell anybody what happened to them, well, let's say Hawaii is maybe not the place you need to be. So Lori Vallow, she's been charged in the death of J.J. Tylee and Tammy Daybell with a sundry of other crimes, basically saying that it was for financial remuneration to kill Tammy Vallow and the children because she continued to get basically Social Security benefits of Tylee. That's Lori Vallow. Anyway, Lori Vallow is originally charged with the basically neglect of her children, and she gets arrested, brought back here to the state of Idaho, here in the United States, obviously. Ultimately, they find the remains of JJ and Ty Lee on the property of her now new husband, Chad Daybell. Of course, nobody has any idea how the remains, and I think at least one case, charred or dismembered remains, were found on his property. How did those get there? Oh, no idea. We had no idea. And then ultimately, Lori and Chad are both charged in an indictment alleging all the crimes that I just kind of briefly went through, the murder charges, and then the financial crimes associated with that. So literally from kind of start to finish here, we're talking roughly 3 years, the time that the prosecutor has had to make their case, to build their case. And I said it a couple of weeks ago, and I didn't do a live last week because I was in trial, but I said a couple of weeks ago, if the prosecution, the Lori Vallow Chad Daybell case is set up as such that the prosecution is going to lose this if they keep bumbling it. I think something, that was my words, something to that effect, that they're screwing this up. And their simple response was, well, it doesn't really matter, Judge. We tried, we turned it over, we had it. It's not that big a deal, blah, 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 blah. And I kept saying, it doesn't matter. I get it. You're the prosecutor. You have obligations, not only under your local rules to turn over discovery, but Brady v. Maryland, the United States Supreme Court says you have to turn over everything. And just because there's a lot of stuff, discovery, phone calls, data, interviews, recordings, you have to turn it all over. And here, I hate to say it, is that the biggest case, maybe next to Brian Kohberger, landed in the laps of two small town district attorneys who are prosecuting this case. They had neither the resources nor the infrastructure to handle a case like this. Instead of maybe saying, hey, State Attorney General of Idaho, we need help. This is a little beyond our resources. We need some help. But they didn't do it. Why? Probably because it's the biggest case in Idaho, and they were going to handle it. And there's a lot of people that says that the LDS Church is involved and they're the ones running it. And they may be, but who's got any of that proof? Give me an email, something. I don't know. It's not that I don't believe it. I'm just saying I need some proof. Okay. Anyway, so as case goes on, Lori Vallow doesn't even make it to her initial advisement in this case because she's deemed to be incompetent. She gets a state-appointed attorney to represent her. 10 months later, she ultimately is deemed competent. She has another little stint where they're unsure of her competency. She goes back to the state hospital for about a month. In the meantime, Mr. John Pryor, who's been on this case from the beginning for Chad Daybell, has been working on this case, but apparently never gets through anything, never gets anything done. And his lack of diligence may have just screwed his client today as well. Lots of tactical things that we can talk about here. Now, to the prosecution, boy, did you bungle this or what? Just like I told you it was getting set up to be. Now, did I seriously think the judge was going to dismiss the death penalty? Didn't think Judge Boyce had it in him. I don't think that Judge Boyce is some strong, principled judge that's going to let the chips fall where they may and rely upon the law. I think he's figured that this case is so screwed up that he doesn't want to be the judge that has a death penalty case reversed. And so he's going to just make it a regular old homicide case. So obviously the defense had recommended that the death penalty was going to be dismissed, and they cited a bunch of reasons that should not really have played in whatsoever. First, mental health. Well, she's deemed competent That's mitigation for the jury to continue, not a legal issue for the judge to say, throw the case out. Media coverage. Heck, the judge has gone to great lengths to make sure there isn't excessive media coverage. For the longest time, one of the few channels in the media that were maybe that other than East Idaho News covering this case was us here at CrimeTalk. And not a whole lot of anybody else was watching this case. People are getting bored. It's now 3 years old. What's happening to it? We've kept following it. And the judge has gone to great lengths to make sure that it wasn't going to be a media circus, such to the point that you cannot have cameras in the courtroom. They'll have a little overflow area, which reminds me, Frank, I'm just speaking to Frank, the CrimeTalk producer here, the hardest working man in show business. Did we ever hear back from them? Do we have to send a check, money, so that we can get the audio recordings? We digress just a little bit here, but that's what you get when live TV. That's how things work, where you interrupt and basically ask Frank. So we're willing to pay to get the audio recordings so that we can put them up as soon as we get them when the trial actually begins. Anyway, we digress. And then the other reason for dismissal of the death penalty was the fact that the defense, on behalf of Lori Vallow, said a lot of late disclosures by the state. And they asked the punishment for the late disclosure to get rid of the death penalty. That's what the defense was asking for. I don't even think that Mr. Archibald thought that this stood a chance in, you know what, to be granted. But Judge Boyce did it. Okay. And Judge Boyce said, there is a heightened level of scrutiny with a death penalty case, which is true. You literally get hyper due process. Okay. Says the court determines that the late disclosure of discovery has materially prejudiced the right to prepare for a death defense, Judge Boyce said. The state turned over evidence they had to the defense on March 13th, which Boyce said was too late for preparation in midst of Vallow's trial to take place, obviously start on April 3rd in Ada County. So we're literally, 10 days away here? 9 days, 11 days? Says the court is required to fashion a remedy that honors the fundamental right to a fair trial. Boyce said as an appropriate discovery sanction, the state will be precluded from seeking the death penalty at trial. Wow. Boyce said he's not punishing the state. He doesn't believe that prosecutors intentionally kept evidence, but rather said he is ensuring the rights of Vallow are protected so a reasonable defense can be prepared. So what does that really mean? Well, I'm not saying it's bad faith on the part of the prosecution, but really what he's saying is it's incompetence on the part of the prosecution. You had this information. You didn't turn it over until March 13th, which was 8 days ago. And apparently the material turned over was significant enough that the judge thought that it was going to affect this case. And basically saying that this case is basically that the state, Judge Boyce said that the late disclosure of evidence by state prosecutors, although not malicious, the case could be turned over on appeal if there was a capital conviction. Well, duh. So anyway, what does that really mean? Normally, as a discovery sanction, what happens is the judge either A, offers a continuance with a waiver of speedy trial. Lori Vallow is not willing to do that, which has really put the pressure on the government, but that's kind of their fault as well. The other remedy that the court does is that they will preclude the prosecution from using that evidence in their case in chief or at all. So they can't use it in the case. But to say I'm dismissing a case because of a discovery violation or a charge in this particular case is sentencing enhancement of the death penalty, that's huge. And I was trying to think back when this news broke. Have I ever seen this situation? I cannot think of the death penalty being thrown out in a case of this, particularly for discovery violation. The most I could think about was, or that I could remember, was I had a case years and years ago, and it was a federal case, and it was a prison stabbing case. And there were several defendants. It was kind of a little mini riot that had taken place. And we wanted certain information. And the prosecution was like, yeah, judge, not within our control, possession, not really going to do anything about it, et cetera, et cetera. And so the time came and the judge made an order. I understand your position, but I'm ordering you to get this information. And they didn't do it. And the judge filed a motion to hold one of the young, and he was a kind of a jerk U.S. attorney. He didn't last long. And quickly realized that he, although may think he's smarter with his Ivy League education, that he was not more powerful than a United States District Court judge. And then ultimately, I remember the hearing. It was so funny because they actually flew my client in on a private jet because the judge said, oh, no, we're having a hearing. And he had been transferred to, I think it was Terre Haute at the time. They brought him back. It's amazing what the powers of a federal judge can do. Anyway, we get in there and the judge starts counting. Let me see. How many United States attorneys does it take to respond to a discovery order? And he literally counted 1, 2, 3, 4, 5, 6, 7, because there was every supervisor from every level sitting there in the pews. And ultimately, at the end of the hearing, the defense got what they were going to get. It's not like we were asking for anything unreasonable. And here in the Lori Vallow case, the defense was not asking for anything unreasonable. You're turning over, I think it was 500 calls that you've had for the last 3 years, and you don't turn those over. What are you doing? Remember, the state brought in somebody, I can't even remember her name, the other prosecutor, I haven't seen or heard from her in a while, from like the state of Missouri. Like, what was she doing? Somebody should have been indexing all this stuff. It just shows that they had neither the skills nor the resources or the infrastructure to handle this particular situation. And bottom line is, man, did they get spanked and spanked hard today. So what are the options for the prosecution to do? Well, they can file a motion to reconsider, perhaps, saying, hey, judge, we've had a little time to reflect upon it. We don't think that your decision was well-reasoned. Dismissal of the charges is not only an extreme sanction, maybe it's something you don't necessarily have the ability to do that. Remember, I'm trying to think of the legal authority. Remember, the courts don't get into the charging decisions. It's not really them, but to preclude them from going on the death penalty, that's usually a decision the prosecutor makes. So I'm a little surprised by that. Like I said, normally the sanction is you can't use the evidence, or defense will give you continuance if that's what you want. Lori Vallow, credit to her lawyers, were like, nope, we are not waiving speedy trial. And we'll get back to this in a second. So the dismissal of the death penalty only relates to Lori Vallow, because Chad Daybell, who's, his attorney John Pryor, seems competent enough, but he's a solo one-man show trying to do all this stuff. You can't do it. You can't do it. You simply can't do it by yourself on a death penalty case like this. I don't care how focused you are, how much money you're being paid to be a one-man show on something like that. It's impossible. Okay. The practice of law is almost to the point these days. You cannot be a solo practitioner anymore. It's just too complicated, difficult. There's too many moving parts. The discovery is so complex these days. You simply can't do it. There's just no way, and still be able to make a living. So John Pryor, on behalf of his client Chad Daybell said, "Oh, we'll waive speedy trial. We've done that in the past, etc. We'll do it again, whatever we need to do to effectuate that continuance so that I can be effective." Well, guess what? Now he still has the death penalty counts for him. And so, yeah, it's no longer a death penalty case for Lori Vallow. And remember, part of the reason we went to all this trouble of moving it from Madison and Fremont counties over to Ada County there in Boise was because it was going to be a death penalty case. And now it's not. Yes, there's going to be pretrial publicity no matter where this case is tried. But suddenly, all of a sudden, it's not that big a deal. Now we're talking, this should be a 2-week trial. What can the prosecution do? Like I said, maybe file a motion to reconsider. Hey, judge, you didn't do this. Maybe you don't have the authority to do this. Maybe try to get some relief by an emergency appeal to the Idaho Supreme Court to say, judge, you don't have the authority to do this. But what's that going to do? That's going to delay the trial. Lori Vallow is entitled to it. But if the Idaho Supreme Court were to grant jurisdiction on something, normally then that tolls the speedy trial clock in that regard. So we'll have to wait and see. All right, Frankston, we have a call. Let's see who we got. Good evening, Mama Pink. Mama Pink, you there?
Yeah, can you hear me?
Now I can.
Okay. So, hello, aficionado family.
Good evening. How are you?
I'm fabulous, actually. I'm doing really good. Couple quick things tonight. First of all, I know that Kay and Larry Woodcock are in the chat often, and I'm not the only one that's saying this, but I want them to hear this from all of our voices that we are so sorry that this happened today. I believe the death penalty should still be on the table, but we still have your backs, and we're still here with you, Kay and Larry, and we love you very much. The second thing is, I don't know if you noticed, Scott, but Hempland, Texas has gifted 70 channel memberships tonight to the viewers. I just want to throw them a shout out, man. That's awesome. So my real reason for calling,
wow, thank you,
is they're talking about the firing squad, bringing that back into Idaho because of the chemicals, which I don't know why they just can't give them a nice dose of phenobarbital or fentanyl and let them die happy, right?
I understand.
But if they bring the firing squad back, being that the shooting on the set with Alec Baldwin, they had to take the gun enhancement off of the charges because that did not come into play when the shooting happened.
Correct.
So my question is if Brian Kohlberger is found guilty and he is sentenced to death, would they be able to put the firing squad on the table even if it was not put into law when these crimes were committed?
It would depend on how the law was written. Normally, they're not going to make it retroactive, so to speak. Apparently, Idaho already has the firing squad as an option, but they're trying to beef it up and basically expedite it. So 5 days after the final judgment of conviction enters, after all the appeals, etc. So that would be it. Normally, it's from a date certain moving forward. The legislature would have to be very specific, but then you get into a whole lot of issues. Since if it's more lenient, it can go retroactively. If it goes not so lenient, it's more from the moment moving forward. They'll say, this is effective on July 1st of 2023. So thereafter, any one sentence normally, not necessarily charged after that particular date. But I would depend on the actual language in the statute. Hopefully that answers your question.
It does, but I was kind of wondering because, he may not want the firing squad, but honestly, if he's convicted, of course, he's innocent unless proven guilty. But it just seems that, like, I guess I was associating with the Alec Baldwin issue with that one charge being dropped because of the date that it was done.
It wasn't in place that law. Alec Baldwin, once again, the prosecutor screwed that up. Why did nobody look and say, hey, this law was in effect literally almost a year, goes into effect a year after the alleged incident took place? Why did they not catch that? Makes no sense to me.
Because they want him to pay because he's so arrogant.
Well, I know, but they're the ones that look stupid because it wasn't a law in the book at the time that the alleged offense took place. I mean, this is the problem. Sometimes these prosecutors, they get over their skis and they get so overwhelmed, right? As a defense attorney, I have to constantly talk to my clients and set expectations and say, this is possible, this isn't, etc. And sometimes these prosecutors get a little, like I said, ahead of their skis, and they don't, read the law to see what the effective date was. So focused on counting pennies for this trial that they're not doing the important stuff, which was making sure all the discovery was turned over. That's the most important thing that a prosecutor can do. At the end of the day, the judge has some duty to protect the record. At the end of the day, it's ultimately the prosecutor to do that. And the prosecutor is the one that's going to help make that record. And if they're not turning stuff over and it is so egregious that the court says, I'm dismissing a death penalty charge against somebody, they can't consider that. That has to be pretty egregious, or the court has to say, this is so screwed up.
Uh-oh.
Are you there? The call. Can you hear me? Oh, I think we lost you, Frank. Yeah. That's right. So I understand Mama Pink's frustration. But at the end of the day, I'm a little surprised Judge Boyce had it in him, but he seems to be getting, I guess, a little more frustrated as things go on, that nothing ever gets done in his courtroom. And when it's done, it's all done in secrecy. And then all of a sudden, here's this bombshell. And nobody really saw it coming. But, I would bet money. That not even the defense thought the court was going to grant that motion. They are probably grinning from ear to ear tonight. And I feel for, Larry and Kay Woodcock. I really do. And I can only imagine the anger that they're feeling right now. And yes, some of their anger should be directed at Judge Boyce, but a lot of that anger should be directed towards the prosecutors in this case. You can go back and look. I said I was getting worried that this thing is so screwed up, it's going to come back on appeal, whatever happens, because they kept, they were just dismissive. It was that, and I hate to say it because it was that kind of that arrogant prosecutor mentality. Judge, we're turning everything over as quick as we can. What do you want me to do? They could have come over and looked for it. I get it. But how do you know what you're looking for when they say everything's been turned over? Where am I supposed to go look? And then they said, oh, we finally searched something out, or something else is referenced in the discovery. And you say, where is this? The prosecutor goes, well, I don't know. Not my problem. And that's, prosecutors can get a little big for their britches sometimes, because normally the judges rule in their favor. Normally the rulings go in their favor because the law is written so pro prosecution. That's the way it is. I get that. So you had to screw this case up pretty big time for the judge to say, this is so screwed up that there's no doubt that this is going to be reversed on appeal. So we're not even going there. And, hats off to Mr. Archibald. I'm not saying this is great news, but I'm saying we want people accused of a crime to have good legal representation so that if there is a post-conviction relief that's sought, saying somebody was ineffective, we want them to say, no, they have effective and competent counsel. And Lori Vallow is the one that holds the right to waive speedy trial. She refused to do so. Archibald and his team said, this is tough, but we're going to do it. They did file the one motion, and they had their mitigation expert said basically there's no way for us to do this. And they just turned over, another 5,000 pages or 5,000 telephone calls. And literally in a death penalty case, everybody's got to review everything. You got to review it. And for the prosecution to say, oh, sorry about that. Another 5,000 calls. Sorry. You probably want a continuance, don't you? You want to waive speedy trial? That's what the prosecution was trying to do. And once again, if you go back 3 years. 3 years. I said, if I was Lori Vallow and Chad Daybell's attorney, I would have marched them in there and pled them, at least Lori Vallow, to the neglect. And then you would have all argued compulsory joinder. You guys had your shot. And, she spends the next 3 years or whatever I think the maximum penalty was. When the charges came up as it related to the bodies on the scene at the house of Chad Daybell, they could have got in there and pled guilty and wrapped the case up. Yes, there are unknowns, uncertainties, but that's where you expect your client to be absolutely honest with you. Hey, if you had something to do with this, now would be a good time to tell me. We're going to go in and plead guilty without a plea agreement. We're just going to go do it. That would have been the time. I'm telling you, and this, I hate to say I told you so, but you go back and look at previous videos that we've done where we've talked about this. Homicide cases. Some of the best results I've ever had in homicide cases was when we said, we're ready to go to trial. First setting. Let's do it. Let's go. And prosecutors like, we're going to seek a continuance, aren't you? No. Hey, Frank, the secret signal to Frank that the food delivery people are here for dinner. So, like I said, the prosecution's had 3 years to build this case. 3 years. They have to turn over everything. Why did they not do it? They know all those calls are being recorded. That is probably the biggest issue you get these days is jail calls. Heck, look at the Alex Murdaugh case. Jail calls. Everybody and their brother knows that they're being recorded. And I'm telling you, it's not like 20 years ago where some of them were recorded. Oh, it's not digital. These days, literally the prosecutors can access the system now and they download the calls from the jail. And anytime there's a homicide case, they're listening. I had to advise a new client the other day about that. Here's a homicide case. They're going to be listening to your calls. I know it's going to be hard to not discuss the one thing that keeps you in custody, but you have to do it. Maintain that discipline. It's just the way it is. So I don't want to sound like I'm just dumping on the prosecution, but this was their case. And they've screwed it up. What's the easiest way to say it? They've screwed it up. And if they've screwed this up, I mean, they're stunned. If this is like a boxing match, they're stunned in days before they even get started. Remember, these are the elected DAs down there. They were more worried about funding and keeping the cases together to make it convenient for them instead of doing what prosecutors are supposed to do. This is why they didn't have the resources to do it. When you have a DA's office of 2 people and 1 support staff on a death penalty case, you can't do it. A death penalty case, the prosecutors usually assign 2 to 3 attorneys plus an investigator, and it is a full-time job for them, usually over the course of the years. These guys don't have the resources to do that, and they're counting pennies. The elected DA should have had somebody handle that case and not do it themselves. They didn't have the resources, or, sucked up their pride a little bit, called the state AG and say, hey, we're a small jurisdiction. This is a big deal. It's a big case. Come up with a reason to recuse, or just say we don't have the resources to do it. Obviously, like in the Alec Murdaugh case, the local prosecutors down there said, we recuse ourselves. We know Alec Murdaugh. Appearance of impropriety. They brought in the state AG. State AG did a pretty good job. Why didn't they do that in Idaho? This is a little shocking to me. And don't get me wrong, Judge Boyce, he's probably going to get a few glaring looks when he gets back to Fremont and Madison County down there. I don't think he's going to be, endeared by the local community, so to speak. So maybe he was just doing what he felt was right. And I think he's kind of saying, hey, prosecution, you've screwed this thing up. And there's no way you'd get a death penalty on this. No way, no how, And so guess what? We are not going to do it. So, all right. If you want to call in, let me know how you feel about this. 725-228-TALK. 725-228-8255. Let me know how you feel. Who do we got? Crime Curious. What's on your mind? Nope. Lost her. Nadine. Good evening.
Hello?
Can you hear me?
I can.
All right, Nadine, what's on your mind? What do you think of this Lori Vallow development?
Okay, I've been watching. I actually live in Canada.
Okay.
But I find the trials really interesting because we don't get to see them here. But since Lori is going first and then Chad, if she's convicted, will it be more likely that he will be, since everybody will already know the outcome of her trial and the jury pool will be not as open?
Yeah, I mean, it really depends on your perspective. I personally like to go first if there's a multi-co-defendant stuff, because the first, second, third trial, whatever it may be, the DA gets to practice. They get to refine their case. By the time they get to the last guy on the totem pole, they know what everybody's going to say. They're completely locked into the story. You can't hear me? Can you hear me now, Nadine?
Hello?
Can you hear me now? Oh, we're losing people. I'm not sure. Yeah, maybe it's calling studio. I don't know. Well, I'll try to answer that question. Hopefully, Nadine, you can try calling back, but hopefully I can answer your question. Hello? Can you hear me? Nadine? I don't think she can hear me. All right, we'll just let her go. All right, well, Nadine's question is, does it make it worse for Chad Daybell? Absolutely. Like I said, I like to go first in a multi-co-defendant case. Don't give everybody the opportunity to, practice what's going to take place. Let's get them up there on the stand. Let's not let the witnesses feel comfortable. Like, oh, I can do this. This is great. This is not so bad. Yeah, we want to have that anticipation of surprise on them. Definitely looks worse for Chad Daybell. Obviously, he still has the death penalty on him because he didn't exercise his right to a speedy trial, which, you have to have tough conversations with clients, and oftentimes they're scared. Well, I don't want to go trial. We need more time. Maybe things will change, right? They're going to realize that I'm not as bad guy as everybody thinks I am. Well, sometimes the reason they're not going to do that is because you want to go to trial. There's no way they can usually get this done. Could you imagine, in any way possible, the prosecution, and go back and look at the videos from 2.5 years ago, if Lori Vallow and Chad Daybell had said, I want my trial within 6 months, regardless of what the evidence was be, does anybody here, by a show of hands, think the prosecution could have been prepared to go to trial? That's what I thought. I don't think they would have. All right. We have a call, Frank? Not sure what's going on with our call-in line tonight. It's like dropping people. Let's try again. Nadine, are you there?
Hello?
Can you hear me now?
Hi, yes. I'm so sorry. My call must have dropped.
Yeah, I wasn't sure. You were gone. So I don't know if you heard my answer to maybe your question,
I
but
didn't.
go ahead. What else is on your mind?
I'm sorry. Yeah. I was just also wondering about if Chad and his attorneys would want cameras, would they allow it or probably not?
Chad Daybell's attorney said he wanted cameras, but since the prosecution didn't want it, the court said, no, we're not going to do it. But once again, the elected district attorney, the people, so we could see how they prosecute cases. Why would they not want this televised for the people of their county, their state, their country, the world to see? Hey, come to Idaho, commit a crime, and this is what's going to happen to you. Because right now, they're looking like a bunch of bumbling idiots. And I hate to say it, but they bumbled this. I mean, think about how bad. We haven't even heard the crux of everything that is apparently bungled right here. The judge has been doing this basically in closed hearing, limited some motions hearings. So for him to conclude that he needs to dismiss this because there's no doubt in his mind that this would be reversed on appeal, that's a pretty bold move. I think the only ones that can change this decision are going to be and would be the Idaho Supreme Court. So the prosecutors better figure out how a higher court could potentially review this decision and put it on an expedited briefing schedule so that this trial can commence. Now, obviously, if the Supreme Court takes the case up, then they wouldn't. A speedy trial would be told. But there's a lot of planning and everything's going on in this particular case. So, and now it's just a good old-fashioned murder case. So, Nadine, you there?
No.
Nope.
We got 2 more calls.
All right. Let's try it. We got another 2 calls. Go ahead. Hello.
Hello.
Good evening. How are you?
Oh, hello, Mr. Rice. I really enjoy watching your show. I was curious about your understanding of the Julie Minot case out of Milford, Connecticut. I'm not sure if you covered that in your show last few episodes.
Have not been covering that case.
In December.
No. I mean, I read a lot. I read a lot about cases, but sometimes the names don't always click, and we don't always talk about them because we could literally go all day.
You mentioned. You mentioned one of these other cases with the dentist.
Yes.
With his wife, and that case, the case in Milford, Connecticut. I think it's. I'm not sure if you covered it, but I think it's probably worth reviewing and maybe following if there's coverage on it over the media.
We will take a look into it. We'll take a look into it.
Well,
have you been following the Lori Vallow
I love
case?
watching your show, by the way.
Well, thank you very much.
I have been following the Lori Vallow case. Yes.
Well, what do you think of today's news?
Today's news with Lori. I think maybe like you said, the prosecution could do better. It's the burden's on the prosecution, so to say, but
yep.
I don't think it'll be over in the next year.
No, I don't think it will be either. But it's really interesting to see. I mean, we're a couple of weeks away now from the prosecution starting jury selection. And then they're actually going to have to call witnesses to state their case. And Lori Vallow said, hey, I'm not guilty. And in fact, the time when JJ and Tylee were supposedly killed, she says she has an alibi. She didn't do it. And the prosecution has to put together a conspiracy before they can put in any statements for that conspiracy. There needs to be a pretrial determination that a conspiracy existed before they can start putting in statements in furtherance of that conspiracy. So we'll have to wait and see. I mean, I don't know how many murder trials these two prosecutors have done, but I'm a little concerned. I'm not gonna lie. I think everyone should be a little concerned with the prosecution at this point.
Well, I'm coming from California, so hopefully the coverage will reach me in enough time to where there's a result.
Well, we're going to try to at least get the audio and put it up. We haven't got the official amount. They said, "Oh, it's going to be X amount of dollars." Like, okay, just give it to me. I mean, I think the world, everybody should see how the courts take place, how they operate, how they function. You know, there's good prosecutors. There's not such great prosecutors. There's good defense attorneys, and there's great defense attorneys. There's good judges and not bad judges. So the world should see how the whole system operates. So we're going to try to bring it to you.
Yes, sir. Awesome. Thank you. Have a good day.
All right. Have a wonderful night. Thanks for listening. Thanks there. Let's oh, I missed it. Somebody said, like, I'll pitch in, Scott. No, we're not asking for money. I'll pay whatever the cost is. I just want to get it put up. I just need a response back from the courts to say, where do I send the check? How do I pay you? Do you want a check? You want a credit card? You tell me. On Texas time. That's right. Sunshine laws, like anything, right? The sunlight makes all the cockroaches disappear, brings them out. Must do that. San Animals Fire. Should the AG step in? I don't think they can, just because you don't like the ruling. You gotta, the prosecutors would have to do that. Yeah, the cost is $60 a day. I get that, and I'll pay that. It's not a big deal. I just want to be able to. They won't let me. They haven't told me how do I pay for it. So we'll get it done. Large Marge. I get it. This is a tough case. I'm telling you, I may have had a conversation with someone very connected to this case today. Let's just say they were not happy. Let's just say they were not happy at all. Next call. Good evening. Carol. Carol.
Hello, Scott. Thank you for taking the call.
Of course. What's on your mind?
Why doesn't the spousal privilege apply with the Vallow Daybell case?
You're talking about the spousal immunity privilege, basically, like attorney-client, priest-penitent privilege? Is that what you're saying?
Not testifying against your husband or your husband testifying against you?
Well, there's no indication that either one of them is going to testify against each other. So it's not really an issue at this point. Most states have statutes that say there can still be a marital privilege with the exception of crimes against children. I believe Idaho has that. So the marital privilege would not apply. Now, the prosecutor can't call them to the stand because they've been charged. So they all have the right to exercise their right to remain silent pursuant to the Fifth Amendment of the United States Constitution.
So that's all they would do if they were on the stand, is just exercise their right to stay silent.
Say that again?
Under advisement of their lawyer. The lawyer would advise them to take the fifth on the stand anyway.
Well, you can't. That would be done pre-trial. That could potentially result in a mistrial if somebody asserts the fifth on the stand. And you can't call somebody to the stand knowing they're going to take the fifth. You can't do it.
Right. I learned that. Also, I'm sorry to hear that Barry Morphew, he's just looking around free, huh?
Barry Morphew's booking around free. In fact, there was a little update. Speaking of discovery issues, you starting to notice a trend here? remember, Morphew, the prosecution, once again, small town prosecutor had a problem
lost you.
getting all the discovery available. Do I lose you?
Yeah,
That's so weird. I don't know what's going on with that. But anyway, yeah, Barry Morphew. The prosecutor up there got sanctioned because she didn't complete her continuing legal education credits, so she was suspended. Kind of a problem when you're the prosecuting DA. But in the Barry Morphew case, once again, discovery violations. And the judge was going to gut the case so that basically a lot of witnesses were going to be unable to testify. The prosecution then dismissed. Well, guess what? Same jurisdiction, same prosecutor, same issue. There is, I think it was an attempted murder or murder case up there getting dismissed. But the courts are having enough of the prosecutors not turning stuff over. It's a problem. And they always get a pass. And finally, some courts are saying enough is enough. Some jurisdictions are very good at discovery. Others suck. And not to disparage small jurisdictions, I love going to small jurisdictions. It's interesting. It's fun. It's a change of pace. And it's just a different world. Usually, when it comes to discovery, they always screw it up, and it usually works to your advantage. So it's just something that it never seems to work out. And so, yeah, Barry Morphew, remember, that was one of the cases that, hey, but remember the DA? Remember the DA last summer? Like, hey, where's the body? Remember, we know where the body is. As soon as the snow melts, we're going to go get it. Yeah. Where's that? Judge, I think Stanley was her name, Linda Stanley. Where is that? So once again, prosecutors getting over their skis, charging cases, don't have experience with this stuff. It's kind of a big deal. So speaking of other cases, let's take a look at this. Is obviously Lori Vallow, huge case. Going to start here in a couple of weeks. Hopefully we'll be able to at least bring you the audio of it, since the judge isn't going to allow contemporaneous streaming or audio of it. We're going to have to basically get it at the end of the day. But I think it's going to be all digital, so we can just put it up. So that ought to be interesting. It's going to be interesting, to say the least. Savannah wants to know, can the prosecution lose these cases outright? Yes. I'm getting a little worried. I hate to sound like, some pessimist, because nobody wants the bad guy to go free if they did it, right? Nobody does. But remember, it's not the defense. It's not the defense if the prosecution fails to prove their case beyond a reasonable doubt. That means the prosecution failed. It wasn't that the defense got off on some technicality. It's called the United States Constitution. All those technicalities are legally rooted, fundamental legal principles that come directly from our Constitution and Bill of Rights. Ladies and gentlemen, the government has a heavy burden, one that they should gratefully accept and say, we're going to meet that. And I hate to keep sounding like a broken record, but I'm telling ya, any good prosecutor is going to say, I'm going to give you everything you want. You tell me the date, you tell me the time and place, and we will be there ready to go. And these prosecutors on the Lori Vallow, Chad Daybell case, they've never been ready. They always want a continuance, and they were more worried about nickel and diming the expenses than actually go and to try the case. And so far, it's all backfired. They wanted to do one case at one time. Now they got severed cases. They're going to have to try this case twice. And on top of that, because Lori Vallow exercised her right to speedy trial, guess what? She just got the death penalty charges dismissed. So we'll have to wait and see. This is Little Flower. I say it's not a coincidence that their bodies were buried in this yard. I agree. What a coincidence. Imagine that, right? But guess what? What does the prosecution have to prove? They have to prove that Lori Vallow did it or was in a conspiracy that she did it. Because her position is Alex Cox, her brother, is the one that did it, and that she was in Chad's, or she was in an apartment with Chad Daybell and another friend of hers. So she could not have possibly have done this. Just saying, that's going to be her defense. They're my kids. I love them. Oh my gosh. All the stuff that, the defense will limit it. The fact that she ran off, she didn't cooperate. I mean, some of that, a lot of that will come in and goes to consciousness of guilt. But that is, that's just the way it is. We'll have to wait and see. But they have to be convinced that there was a conspiracy, not just a bunch of people with some crazy attitudes regarding the end of the world coming. And Alex Cox, her brother, who had obviously killed Charles Vallow down there in Arizona, that he didn't go do something on his own. That's going to be the difficult part for the prosecution. Just saying, something to think about. Something to think about. Anyway, wow, can you believe it's already been an hour? It just seems like that, doesn't it? It goes by so fast. All right, everyone, guess what we need to do? If you would like to continue the conversation, we're going to figure out what's wrong with our phone call system. And then our Patreons can also call in as well. We'll do a little magic 8-ball. We'll just have to wait and see what the question will be. But wow, yeah, it's going to be interesting. And like I said, hopefully the prosecution can rebound from this and put on their trial face and get in that trial psychosis mode and go try this thing instead of worrying about nickel and diming expenses. As my boss once told me in the military, is when I asked, why are we bringing all these people in from around the world for this little court martial? And the Colonel Khan said, there's always money for justice. That's what happens when you nickel and dime stuff like that. It just messes up. Didn't get to talk about the phone call between Alec Murdaugh and his attorney, Jim Griffin. I guess we'll have to do that on the Patreon show. But I got a real problem with why that was even being recorded. Why? The fact that it was turned over by mistake, please don't disseminate that. We haven't put it up. Frankly, I don't think there's anything particularly earth-shattering about that. But I think that was the day that the door got opened up to all the bad stuff. But Mr. Griffin was not in the talking mood at that point. But it shouldn't even been listened to. It was a client, a defendant contacting his attorney. Why did they not just let that not be recorded? I got a real problem with this. The trial that I just did last week, they were trying to find witnesses. They were listening from calls from the jail. And guess what? They had like 20 calls from my client and me. And they're like, oh, of course we didn't listen to him. Oh, no, we didn't. I take them at their word. Take them at their word when they say they didn't. But why is it even being recorded? Anyway. All right. Come join us on our Patreon show here in just a couple of minutes. If you're a Patreon, you'll get the link and the conversation will continue. A lot of breaking news, more to come on all of this tomorrow. So keep watching, not only right now over on our Patreon show, but keep watching Crime Talk. Thanks for being here, and we'll see you next time.